Gender Identity and Expression, Working Towards an Inclusive Workplace is the final von Schoeneck King Complementary Diversity, Equity, and Inclusion webinar for 2021. This year, we have discussed structural racism, bias against AAPI communities, marriage equality, and much more. Today's program fits in very well with this catalog and overall conversation, which intends to help us all work to create more equitable communities and a more inclusive legal profession. Our speaker today is Teresa Resnick. Teresa is an associate in the firm's labor department. She represents employers from across New York State, and I will say that building relationships with those clients is really at the center of her practice, and she strives to always give top-notch legal services, as our team here does. Teresa is recently appointed as a member of the New York State Bar Association's Task Force on the Treatment of Transgender Youth in Sports. She was appointed by New York State Bar President Andrew Brown. She spent a lot of her own time gaining knowledge on inclusive environments and educating herself regarding gender identity. Her research and learning in the area of gender identity serves her clients, the firm, and now the New York State Bar Association and our profession very well. I know I learn a great deal from her every time we talk about these issues, and I'm very grateful that she's agreed to share some of that knowledge with all of you today. So I'm now going to turn this over to Teresa.
All right, thank you, Kim, and thank you everyone for joining us. Good afternoon. As Kim said, I'm Teresa Resnick. I'm going to be discussing gender identity in the workplace. This is a CLE, of course. We're offering this for CLE credit, but I'm going to try to focus this more towards the practical side of things and not focus too much on the legal side of things, which I'm sure will be welcome to almost everybody listening. So as Kim said, she gave me a very nice introduction. This is me. For those of you that don't know me, I'm a labor and employment attorney. I practice in a wide variety of management-based labor and employment areas. There's more information about me on my LinkedIn page and then at the firm's bio as well. And then that's my contact information. Should you want to get in touch with me, I always enjoy talking about this topic, as you're going to see. So things we're going to be discussing today. So we're going to start by a glossary of terms. I think it's important when we're talking about gender identity and sexual orientation to make sure everybody understands how we're using the terms that we're using. So we're going to go through and discuss what some of the more commonly used terms in this area mean. We're going to then turn to federal laws impacting gender identity. We had a big Supreme Court case on that topic last year, right in the middle of the worst of the pandemic for many states. Then we have state laws impacting gender identity, specifically New York state laws impacting gender identity. We have one that's coming up December 21st is the effective date for that. We have pronouns and restrooms. I'm including that as well as religious and medical considerations, because I see those really as the four most practical areas where I can be useful and give guidance on this topic. They're also the four most common areas where I see questions about this topic. What do we do about someone who has this gender identity, who wants to use this restroom or wants to, have this pronoun, or what do we do if there's someone who has a religious objection, or what if this person needs an accommodation? All those questions, I think, trend more towards the practical side of things. And then at the end, I'm going to give some helpful tips and case studies. And Kim will interrupt me somewhere in there and give you all the CLE code. Okay, so some thoughts to guide our discussion. It's always my intention when discussing gender identity and sexual orientation, and really anytime I do a presentation, but especially this one, to have an open and honest and respectful conversation. I do encourage anyone who has questions to ask them. Kim will be monitoring the Q&A and the chat function. Just so you know, I think there's no such thing as a bad question. I assume that all questions, even if they may not be worded perfectly, come from a place of good intent, and I'd encourage others to do the same. When we're talking about gender identity and sexual orientation, it's important to remember that people have unique life experiences that guide their perceptions and beliefs. Everybody comes to this topic with their own lens, and I think it's important to be respectful of one another's views, opinions, and experiences as we go through the presentation today. So just to give you a sense of some of the statistics surrounding this, and I promise this isn't a statistics presentation, but I do think the statistics are important because they show that there is still quite a bit of workplace inequality for people who don't identify as strictly male or female, or who have a sexual orientation other than straight. So I've included some statistics here. There's not a ton of studies on this, which I think is another marker of prejudice and bias against these people that we haven't really undertaken to do any good research to see how much workplace inequalities impact them, but I've included the best statistics that I can. So in 2017, there was an NPR study that just told us that at that time, about 1.5% of Americans identify as transgender, genderqueer, or gender nonconforming, and 57% of LGBTQ Americans have experienced slurs about their sexual orientation or gender identity. And this will not be a surprise to many. The sobering statistic is discrimination, harassment, and assault against LGBTQ people of color occurs at the highest rates, even within that community. A couple of years before that, the National Center for Transgender Equality did a survey. They found that 47% of trans people have been sexually assaulted during their lifetimes, and 46% were verbally harassed for being transgender. Generally, trans and non-binary individuals experience physical and sexual assault at higher rates than cisgender people. So the discrimination, bias, and criminal acts against these people is very real. The most updated survey I could find in terms of workplace was actually one from just a couple months ago, from September 2021 by the UCLA School of Law. That found that 1 in 10 LGBTQ workers experienced discrimination at work within the last year. So that's not even within their entire working experience. That's within the last year. LGBTQ employees of color were more likely to report being denied jobs and being verbally harassed. 50% of LGBTQ employees are not out to their current supervisor, and 26% aren't out to any coworkers, which means nobody that they work with knows that they identify as part of the LGBTQ community. And 34% of LGBTQ employees have left a job due to treatment by their employer. So those statistics are not fun to read. I've labeled them sobering statistics for a reason, but I do think they highlight how important it is that we do things like this and really start to learn about how we can eliminate our own biases and prejudices and be more inclusive of people of all gender identities and sexual orientations in the workplace. So some terms, I told you I'm going to start with terms, and I am. Some of these will probably be very familiar to you. Some may be less so please bear with me. I want to make sure we're all relatively on the same page. So I'm going to start with the LGBTQ+. L stands for lesbian, a woman who is sexually or romantically attracted to other women. The G is for gay, most often associated with men, but it broadly means a person who is sexually or romantically attracted to people of the same gender. The B is bisexual, a person who is sexually and or romantically attracted to men and women. The T is for transgender, a person whose gender identity does not correspond to the gender they were assigned at birth. Questioning, someone who's unsure about their orientation and or gender identity. And then the plus is inclusive of all gender identities and expressions. These definitions come from the Out Alliance of Rochester, New York. I took a class with them a couple of years ago, and they continue to graciously allow me to use their materials. So if you're wondering where those definitions come from, they do come from there. I know people can subscribe different definitions to many of these terms, as well as the terms we're going to be talking about. So I just want to be clear about where these terms come from. And we'll talk more about what terms we use when people use different terms for themselves in a couple of slides. So this is the longer LGBTQ abbreviation, and I know there's one's even longer than this, but this is probably the second most common one that you would see. So, and I think some of the terms included in it are important as well. So the other Q stands for queer, a term used to define any orientation that is not straight or any gender that is not cisgender. We'll talk specifically about the use of the word queer in a couple of slides. It is still perceived by some people in the LGBTQ community and outside of the community to be a derogatory term. Throughout the past couple of years, maybe the past decade, there has been some work within the community to reclaim the term. But I would say if you're not within the LGBTQ community, be very careful before using that term to describe someone that is. The I stands for intersex, when chromosomes or biological sex are not typical. The A is for asexual, the first A, lower absent sexual attraction. The second A is for ally, a person not part of the LGBTQ community, but who advocates for the rights of people in that group. The The two is for two-spirit, which is an indigenous North American term meaning people who have the spirit of both man and woman or are of a third gender. The first P is for pansexual, sexually attracted to people regardless of their gender. And then the last one is polyamorous, engaging in more than one sexual or romantic relationship simultaneously. A couple more terms, sexual orientation. When I say that, I mean the part of a person's identity related to whom they are sexually attracted. Cisgender, a person whose gender identity matches the sex they were assigned at birth. I know I hear the term cisgender used a lot, even in the media, and I hear it used incorrectly. Straight, a person who's a man who's attracted to a woman and vice versa. Non-binary, someone who doesn't identify as male or female. They might identify as both, neither, or non-gendered. And then gender fluid, a person whose gender identity fluctuates. And so by now you're probably thinking that's all the terms that there could possibly be, but there are so many more terms that we can use when we talk about gender identity and sexual orientation. I'm not going to go through all of them, although I do think it's a wonderful use of your time and a wonderful way to better understand the English language if you were to go through and look these up. It's a little outside the scope of what I'm going to do today, but these are just some of the examples of other terms that people use to describe themselves and others. I often get asked, why are there so many terms? And there are so many terms because inclusivity and identity and discussion matters. It makes people feel seen, it makes them feel heard, and it's important that they have an identity. Okay, so we have a lot of good terms that you can use. Here are some disfavored terms, and I'm not saying you're never going to hear these, particularly within the LGBTQ community, but if you're outside of that community or not sure if you should be using these terms, I would err on the side of not doing so. So some of these are transvestite or transsexual. Those have been disfavored in favor of transgender. Sex reassignment surgery, or SRS, is now known as gender confirmation surgery. We don't say lifestyle choice or alternative lifestyle anymore. That's considered just not correct. Sexual preference, again, it's not really someone's sexual preference, it's their identity. Same thing with preferred pronouns. I hear preferred pronouns used a lot, again, even in the national media. Preferred pronouns has really fallen out of favor in exchange for the term correct pronouns, or even just what are your pronouns. Using preferred pronouns, again, suggests that there's a level of choice there that may not necessarily be there. Hermaphrodite has been set aside for use of the word intersex, which we talked about. And then I have gender nonconforming, and I would add non-binary to that with a question mark. I do still hear those terms used, but more and more commonly these days, I hear gender expansive being used. So I would err on the side of using that if you can. But in general, and this will be a rule that we repeat throughout the presentation, use the terms that people use for themselves or that they ask you to use, specifically the ones that they ask you to use. That's always going to be the best way to make someone feel comfortable and included. So what if I make a mistake? Everyone makes mistakes. Even people with the best of intentions can make mistakes. When that happens, I suggest that you don't avoid the mistake. You just apologize quickly and politely. Excuse me, or I didn't mean to. Don't over apologize. There's no need to make this into a big production about you. It's not. It was a simple mistake. Just apologize and move on. If you're nervous, when starting a conversation, you can announce that you mean to be respectful, and please, ask people to correct you. And then that might make them feel more comfortable doing so, and you're going to learn more quickly as well. When I talk about different names and different pronouns, then perhaps you knew the person prior to them changing their name or pronouns. I often think of a lot of women when they get married change their names. If we, after a couple of weeks, can get used to their new married name, there's no reason that after a couple of weeks we can't get used to someone's new first name or new pronouns or correct name or correct pronouns. So I think apply the same level of grace to both of those scenarios and you'll be doing fine. This is the genderbread person. I think this is a useful graphic. It goes through the differences between gender identity, gender expression, and biological sex, as well as sexual and romantic attraction. I just include this as a fun graphic. I encourage you to refer to it for a quick reference if you're struggling with the difference between those terms. Okay, I'm going to go on to federal laws and gender identity, and I'm going to start with a trio of Supreme Court cases. I'm going to go through and describe some of the factual background in those cases because I think it's relevant and interesting, particularly when it comes to the Supreme Court's ultimate decision. So these are cases that were decided together. The first one, in the case that commonly envelopes the others, is Bostock versus Clayton County. Gerald Bostock worked for Clayton County, Georgia as a child welfare coordinator. In 2013, he began playing in a recreational softball league for gay men. County officials criticized his participation in the league. 1 month later, he was terminated for conduct unbecoming of a county employee. So he was the first case that got appealed to the Supreme Court that the Supreme Court agreed to hear. The second one was actually from our circuit, the Second Circuit. This was Zarda versus Altitude Express. Many of you may have heard of this case. Donald Zarda was a skydiving instructor working for Altitude Express on Long Island. He disclosed his sexual orientation to women who were concerned about being strapped closely to him while he was skydiving. The company found out that he was disclosing this information, and in June 2010, they terminated him for sharing inappropriate information about his personal life with a client of the business. And then finally, we have the EEOC versus RG and GR Harris Funeral Homes. This was Amy Stevens, was working as a funeral director and an embalmer at Harris Funeral Homes in Livonia, Michigan. Ms. Stevens was assigned the male gender at birth. In 2014, after working for Harris as a male for several years, she told her employer in a letter that she would be coming to work as her authentic self, wearing women's clothing. 2 weeks later, she was terminated because the funeral home felt that her gender identity would be upsetting to customers and also felt that her gender identity was a violation of the owner of the funeral home's personal religious beliefs. The Supreme Court ruled on these cases on June 15th, 2020, and they found that Title VII protects gender identity and sexual orientation as connected to sex, which of course Title VII has long protected. The court wrote, and this was a Justice Gorsuch opinion, an employer who fired an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. And I happen to really think this is a very well-written decision. It comes out very strongly. It's clear in its reasoning. It's not overly long. I included it in your case materials. If you have a couple minutes, I encourage you to read it through. Again, I think it's very well written, and I think it gets to the point in a very concrete way. As a result of that decision, employees who believe that they have been discriminated against, retaliated against, or harassed based on their sexual orientation or gender identity can now bring claims in federal court. Claims under Title VII, if successful, can involve back pay, compensatory damages for emotional distress, punitive damages, and then, of course, employees have 180 to 300 calendar days after the last act of discrimination to file a charge with the EEOC. So what this really did is it said, for the first time, gender identity and sexual orientation are protected under Title VII, and that's huge. It's not as huge for New York as it is for some other states, but in other states where state law hadn't independently protected employees' gender identities or sexual orientation, this case was really groundbreaking. And I think even in New York, we're going to see an impact here because now these cases can be brought in federal court with state court claims attached as opposed to just being brought in state court. One more thing I will say in 2021, June 29th, the Supreme Court declined to hear the Grimm case. This was the case of Gloucester County School Board versus Gavin Grimm. Their refusal to hear the case leaves in place the Fourth Circuit's decision that mandated that Grimm be allowed to use the restrooms that corresponded with his gender identity, and signals, obviously, that the Supreme Court isn't going to hear similar cases in the future and that other courts may rule in the same way as the Fourth Circuit. Gavin Grimm was an individual in a school. He was not being allowed to use the restroom that corresponded with his gender identity. It got up to the Fourth Circuit. The Fourth Circuit mandated that he be allowed to use the restroom that corresponded with his gender identity. So I think that's a good indication, and we're going to talk about restrooms specifically in a couple slides. I think that's a good indication of where the Supreme Court would go on that. So some New York state specific laws on gender identity. As I mentioned, New York is one of the states that already had protections for gender identity and sexual orientation before we had the Supreme Court decision on the federal side. And they primarily did that through GENDA, the Gender Expression Non-Discrimination Act. GENDA amended the human rights law in 2019 by adding gender identity or expression as a protected category. The New York law defines gender identity or expression as a person's actual or perceived gender-related identity, appearance, behavior, expression, or other gender-related characteristics assigned to that person at birth, including but not limited to the status of being transgender. It protects the way a person expresses gender through speech, dress, and behavior. So generally, when we talk about gender identity, we're thinking about how someone identifies as either a man, as a woman, as non-gendered, as gender expansive. And when we talk about gender expression, we think about how people express their gender, how they dress, how they talk. There's certain behaviors that are prescribed as stereotypical to one gender or another. So New York came out affirmatively, and this is still good law under the New York human rights law, that you cannot harass or discriminate anyone based on their gender identity or their expression. For those of you not as familiar with the human rights law, it is illegal to discriminate on the basis of gender identity and expression, which we just discussed, as well as all of these other protected categories. I'm including this to show you that those gender identity and expression now enjoy the same protections as age, as race, as color, as disability. So all the traditional protected categories that we've been living with for most of our lives, we now have gender identity and expression. And of course, sexual orientation has been added to that prior as bases for protection in the workplace. And as a general reminder, you can't retaliate against an individual for filing a complaint, opposing an unlawful practice, or testifying or assisting in an investigation if that investigation or complaint involves one of their protected categories, including, of course, gender identity and gender expression. So that's a heads up on the New York human rights law. Of course, all employers in New York State are bound by that. Since the law was changed a couple of years ago, now if you have even one employee, you're bound by the New York human rights law. One thing I'll mention, and it's not directly related to the workplace, although it does loop in the New York human rights law a little bit, is the Gender Recognition Act. That is effective December 21st, so pretty soon. It was passed back in June. The GRA, or the Gender Recognition Act, allows individuals to change their names and gender markers on New York State identification documents in a streamlined process. So for those of you not familiar with the process it currently was, or prior, or currently, I guess, still currently technically, it was more involved to change your gender marker or your name on New York State legal documents. And there was also a publication requirement that had to be published in a local newspaper saying that you had changed your pronouns or had changed your gender or had changed your name. So this law eliminates that publication requirement. It allows you to sign an attestation form saying that that is your correct name and correct pronouns. You don't have to submit any other type of proof or other documents. Again, that is effective December 21st. And then failure to honor the name and gender marker on an ID under the GRA is a violation of the New York human rights law, and an individual can file a complaint for violation of that law with the Division of Human Rights. So I mentioned that there's more to say on the GRA, of course. It's a whole law in and of itself, but since it's not directly related to workplaces, I just wanted to mention it briefly. But when we talk about workplaces, some of the most common questions I get from employers and employees are, what do we do about people who want to use this restroom and people who don't want them to use that restroom? And what do we do about people who want to be called by a pronoun that's unfamiliar to us or that's different than the pronoun that they had been using prior? So I'll just start by explaining a little bit about gender pronouns. There are a lot of gender pronouns. Just the way we saw that there are a lot of terms for different gender identities, there's a lot of different gender pronouns out there. And it's a wonderful way, again, to explore language, to look at gender neutral pronouns. I think the most common ones you've probably heard before are they, them, and theirs, other than he and her and she and him, the ones that we've been using for a while. But they and them and theirs is probably the most common use. Second to that is ze, them, and zir. It's a fun fact, or at least it's a fun fact to me because I was an English major in college. One of the oldest known uses of a gender neutral pronoun in the English language is actually from 1789, and the pronoun is ow, or at least I think that's how it's pronounced. I couldn't find a 1789 pronunciation, but I include that fun fact because, like I said, it was an English major. It's a fun fact to me. And I also include it because sometimes I hear people say, like, why do we have to keep reinventing the language? Why do we need a gender neutral pronoun? Why can't people just use the language we already have? Why can't they just suck it up and make it easier for everybody else? And I include that to show you that gender neutral pronouns have been around for a really long time. It's not actually anything new. And if you go back, and you all are lucky I didn't include this in this presentation, but if you go back, you can actually trace the use of gender neutral pronouns in the English language throughout English literature history, leading up to the gender neutral pronouns that we have today. So it's not a newfangled idea for all of those people out there who are wondering why we just can't keep things the way that they always were. They always were that we had gender neutral pronouns. They're just a little more visible now. Okay, trending towards the more practical side of things. A failure to use someone's correct pronouns in the workplace is discrimination. That's very clear. That's clear under the New York State human rights law. It's now clear under Title VII as well. You can't discriminate against people by failing to use their correct pronouns. I've included the four most correct commonly used pronouns. All pronouns are correct. The 3 or 4 most commonly used pronouns for the workplace, like I mentioned, they, them, he, him, she, her, or ze, them are the ones that I think we would all be most familiar with. Doesn't mean they're the only ones. It is illegal under New York City and New York State law to use incorrect pronouns. It could also be severe and pervasive harassment under Title VII as well. Because it's newer under Title VII, I don't know how many times or in what context you'd have to use the pronouns incorrectly to get to that severe and pervasive standard, but it is certainly possible. In New York City, violators, and I mean violators who don't use people's correct pronouns, are subject to civil penalties of up to $125,000 and up to $250,000 for willful violations. Generally, and I'll say this again, if you can learn to use a woman's different name after she gets married, you can learn to use someone's different pronouns or name if you were previously introduced to them by a different pronoun or name. It should take about the same period of time to adjust to that change. If someone is continually referred to by the wrong name or the wrong pronouns past that period of adjustment, it starts to look deliberate and intentional, and that's when it veers into the realm of discrimination or harassment. So that's what I have to say on pronouns. When we get to restrooms and gender identity, one of the more common myths, again, like one of the myths we see with pronouns is this is a newfangled thing and why can't people just use the same English language we've been using for years? That's a myth. Another myth is that cisgender women are not safe in restrooms with trans people. There is zero evidence to suggest that that is true. In the 18 states that have policies allowing people to use the restrooms that align with their gender identity, there has not been a single report of a trans person behaving inappropriately in a restroom. That's from 2016. Obviously, we have more than 18 states that allow that now. I still am not aware of a single report of a trans person behaving inappropriately in a restroom. Sadly, the reverse is actually true. Trans people are far more likely to be harassed or harmed in restrooms than any other gender identity. Going back to a 2013 UCLA study, which found that 70% of respondents said they were denied access, harassed, or assaulted in public restrooms. So for people that continue to push this myth that cisgender women are not as safe in restrooms when trans people or people of all gender identities can use the restroom, I really encourage you to encourage those people to educate themselves. That is just a very harmful stereotype, and it's certainly not anything even close to a fact. Another interesting point I think about restrooms is the different agencies and laws that have gotten involved in this debate, and particularly when they've gotten involved in this. The Occupational Safety and Health Administration, which is not necessarily an agency that you'd think would be up on this, is and has been since 2015. OSHA has said that under their sanitation standard, they explicitly favor allowing employees to use the restroom consistent with their gender identity, as failure to do so could become a workplace safety concern. So again, we see a federal agency who really jumped into this before even New York had explicit laws on this back in 2015, and I've included the OSHA guidance in your course materials as well. I think it's interesting, particularly given the agency that it came from and when it came from them. Of course, in New York and under the New York City human rights law, so New York City human rights law, employers must allow employees to use the restroom of their choice. That very much includes the group restroom of their choice. You cannot force a trans person or a gender expansive person to use the single stall or single use restroom. You have to allow them to use the group restroom of their choice. And I'll talk more about that on the next slide. On the federal side of things, the Supreme Court decision is silent specifically on the issue of restrooms. We do have the Gavin Grimm decision with the Fourth Circuit that the Supreme Court declined to hear. I think both of those decisions look cobbled together, indicate that if you fail to allow a trans person or gender expansive person to use the restroom of their choice, including a group restroom of their choice, you very well could put your business in harm's way for a discrimination claim or hostile work environment claim. Again, we don't have case law on that on the federal side yet, but I think we can read the tea leaves and see where that would probably go. Okay, so bottom line, trans and gender expansive employees must be provided with access to facilities that includes restrooms, locker rooms, changing rooms, consistent with their gender identity asserted at work. Employees cannot be required to use a single gender facility that conflicts with that person's gender identity asserted in the workplace. So like I said, you can't force people who are trans or people who are gender expansive to use the single use restroom. You have to allow them to use the group restroom. Employers must provide reasonable alternative arrangements for an employee who expresses a need or desire for increased privacy. That's particularly true if you have a locker room scenario where people have to change in front of one another. Maybe they have to put on specific work clothes or change out of specific work clothes, and you have an employee who expresses a need for privacy. You must provide a reasonable alternate arrangement for that person. Some options for restrooms, and I say generally this is the most inclusive thing you can do. If you have a single-use restroom or you can create one, allow anyone to use it, regardless of their gender identity. So cis gender people can use it, trans people can use it, people who are gender expansive can use it, any of the gender identities we talked about can use it for any reason at any time. So you're not pigeonholing or forcing anyone of any specific gender identity to use that restroom. You're opening it up to everyone. Another thing you can do to indicate that you're an inclusive workplace is use gender neutral signs for restrooms and indicate the same in your policy language. Educate managers and other employees regarding transgender rights and restrooms. That goes for your employees. It also goes for your clients, any customers, vendors, other third parties providing services or interacting with your employees in the workplace. It's just a good inclusive option. Okay, I'm going to turn to religious and medical considerations because along with restrooms and pronouns, there are still some things in flux with religious and medical considerations and still some questions that I get around these areas. So starting off with religious, by now it's probably occurred to some of you that, well, what do we do if one of the employees that works with a trans employee or a gay employee or gender expansive employee says that they won't work with that person because of their religious beliefs? Don't we have to protect that person's individual religious beliefs under the New York City and New York State human rights law, as well as Title VII? So I think this is an important misconception to clear up. So of course, we know that you can't discriminate against someone under New York State law or under federal law in the workplace because of their religious beliefs or practices. However, an employee or employer's actual or perceived religious objections do not justify discrimination, nor do the coworker's beliefs justify the same. It is not a requirement, it is not a violation, of an employee's religious rights in the workplace to require that employee to follow the law. I will note there is one smaller caveat to that. For religious institutions, please remember that Title VII does not apply to employees in ministerial positions. So if you are a religious institution, kind of bifurcate what I'm saying now. For everyone else who's not a religious institution, just know that while you can't discriminate against someone based on their religious beliefs, requiring them to comply with New York and now very likely federal law is not discriminating against them. I tend to say that it may be easier to view this in a broader context or maybe in a different context. And so this may be a helpful example. To refuse to use correct pronouns, work with, or use the restroom of a non-binary or trans person is legally the same level of discrimination as refusing to do any of those things with anyone else because they're in a protected category. So, for example, I refuse to use the bathroom with Susan because she's a trans woman is the same as I refuse to use the bathroom with Susan because of her race. You would never, as an employer, allow an employee to tell you, my religious beliefs don't allow me to use the bathroom with anyone of X race. And therefore, you can't let that person use the bathroom with me, or I'm going to file a discrimination lawsuit against you. Obviously, that is not a religious belief that you would have to condone in the workplace because it would mean being part and parcel to discrimination. Same is true for gender identity, same is true for sexual orientation. So sometimes it can be easier to explain it to people who continue to have these objections about what it looks like in a different context and explain that the same legal standards do apply. So for medical considerations, and I know that this continues to be a hot button topic for employers as well. When it comes to medical conditions and the LGBTQ community, there has been a lot of hurt and harm done by the medical community, but we do still have some medical conditions and considerations associated with people of different gender identities. So the American Psychiatric Association continues to define gender dysphoria as a type of medical condition. It's defined as a conflict between a person's physical or assigned gender and the gender with which they identify. This may cause significant distress and or problems functioning. As I've noted, this is a somewhat controversial term, as many non-binary and transgender and gender expansive people don't believe that they have a psychiatric illness. And it harkens back to when the American Psychiatric Association used to define people who are gay as having a psychiatric illness. Of course, that's been done away with now, but it wasn't so long ago that it's outside of the realm of possibility in this context as well. So I'm mentioning it because as we sit here today, it still is a diagnosable illness by the American Psychiatric Association. I'm also mentioning it because the New York and New York City human rights laws still view gender dysphoria as a disability. And should you have an employee come to you with a diagnosis of gender dysphoria, you have to reasonably accommodate them the same way you'd accommodate anyone else with a disability. So as far as the ADA goes, non-disabling conditions concerning sexual orientation and identity are not necessarily protected under the ADA. The ADA language in this respect is pretty outdated. It uses terms that I have included and have said are no longer in favor. So it's certainly not something I would encourage you to quote in your policies. In 2017, a federal court in Pennsylvania held that gender dysphoria could be a disability under the ADA, not because necessarily of the diagnosis, but because of the physical symptoms that accompany the diagnosis that translated into a more commonly recognized disability. So after this decision, and probably after the Supreme Court's decision as well, there may be grounds to find that gender dysphoria must be reasonably accommodated under the federal law as well. But for right now, know that in New York, it is a disability that you have to accommodate because while the New York human rights law lists gender identity or expression as protected categories, it still also views gender dysphoria as a disability. Employers must engage in the interactive process and reasonably accommodate all individuals with a medical diagnosis of gender dysphoria. I'm adding in here, this is a case where you could ask for medical documentation, and that's a look ahead to something I'm going to talk about in a couple of slides. Generally speaking, and this would be the exception to the general rule, you as an employer are not allowed to ask for medical documentation that someone is really trans or that someone is really a man or someone is really gender expansive. You are not allowed to ask for that medical documentation. In the case where someone is asking for an accommodation based on a disability or medical diagnosis, you can follow your usual procedures and ask for medical documentation in that case. Can an employee get leave under FMLA for, conditions related to being trans or related to being gender expansive. They can, as long as that otherwise qualifies for a serious medical condition. And so if it meets the definition of serious medical condition under FMLA, they certainly can get that leave, even if it's connected to their gender identity. So things like that can be surgery, continued counseling, hormone therapy. It may also be available for different treatments of gender dysphoria. Whenever we talk about medical accommodations or FMLA leave or any other type of paid leave, we know that individual circumstances are always going to dictate the outcomes. The same treatment or process that one person is going through who's trans is not always going to be the same as the process that another person is going through. So as always, individual circumstances are going to dictate our outcomes on that. Okay, so I'm going to pause here and let Kim give all of you the code.
It's very difficult. The code is I for identity. So the CLE
There
code
you go.
today is I for identity. And Teresa, we have a number of questions. I don't know if you want to wait till you go through the tips and
No,
case studies.
I'm gonna keep going.
Okay.
I think some of the questions may be answered. So I'm gonna keep going. And then I'm happy, I should have time, given where we are, to answer questions. So
Sounds great. All right. So again, the code, CLE code is the letter I.
for identity. Okay, so beware of stereotypes. This is what I was getting at with the medical documentation. Transgender and gender expansive people do not have to do any of the following to be legally protected or to be considered really trans or really gender, whatever really you want to put in front of it. So a lot of times people think, oh, you're not really trans, you're not really gender expansive because you haven't changed your legal name. That is not correct. They don't have to do that to be considered legally protected. They also don't have to ask to be called by a different name. They don't have to change their pronouns. Some people do, some people don't. They don't have to have surgery or take medication, including hormones. Again, some people do, some people don't. They don't have to dress in a certain way, and they don't have to produce medical records verifying a transition. Limited exception there, and it wouldn't be for verifying a transition, to be verifying a diagnosis would be in the medical context. So I've included some things to say and then on the next slide, some things not to say when people come out to you. Because if you go back to that statistic I mentioned at the beginning, about 50% of people are not out in the workplace to their supervisors, and 26% aren't out to anyone. So if somebody in the workplace does disclose their gender identity or sexual orientation to you at work, I've included some things that you could say, and then on the next slide, some things you should think about not saying. But generally, when someone comes out to you or expresses to you who they truly are, it means they trust you. And so I suggest that you honor that trust by saying things like, thank you for telling me, or thank you for trusting me. I'm glad you can be yourself around me. How can I support you? Is there anything I can do to help you? I want to make sure I protect your privacy. I won't share this with anyone else unless you want me to. Sometimes people are out at work and they're not out at home. Sometimes people are out at work to their coworkers and not to their supervisor. It can be a difficult situation and a difficult decision about who you want to come out to and who you don't. So always make sure you're letting that person, the person coming out or telling you their gender identity, lead the conversation. And it's never a bad idea to ask them, who else you can use those terms and names in front of, because you want to make sure that you're protecting their privacy. So some things not to say, and I include the same language at the top of this. When someone comes out to you or expresses to you who they truly are, it generally means that they trust you. So please don't betray that trust by saying things like, are you sure? Perhaps it's just a phase. I already knew that. Oh, that doesn't matter to me. When did you decide to be gay, trans, etc.? Are you going to have surgery? How do you know that you're gay, trans? I love, like you, respect you anyway. I suggest you avoid those terms when people are expressing their true selves to you. A lot of them are dismissive, some of them are downright discriminatory, and they're all disfavored. Even if you come from a place of good intention, they may not be interpreted that way by the listener, the person coming out, and of course that's the person that you're trying to respect and show honor to in that moment. So I include them so that you know to avoid them. Some other tips when referring to trans people at a time in their lives before they transitioned, and this goes to some people maybe out at work, but not at home, or vice versa, use their current pronouns and names. That is because people may not know that that person is trans, or that that person had a different name or pronoun use earlier in their life. So the example I use here, because I'm not in danger of outing someone who was on the cover of Vogue, is that Caitlyn Jenner went to the Olympics. So even though Caitlyn Jenner was known by a different name at the time she went to the Olympics, we use her current name and correct name and pronouns to describe her at that time in her life. Don't ask for a person's former name pre-transition. It's a rude question. And I should certainly hope that you're not asking whether a person has had or will have a medical procedure or is on medication. You do not ask that of anybody in the workplace. And just because somebody has told you that they're trans or gender expansive does not give you any kind of right to ask it in this context either. Some other things, use gender neutral terms whenever possible. Avoid terms like sir, madam, ladies, or guys. Instead, use folks, people, everyone, y'all. Sometimes I use citizens. If you're unsure about a pronoun but must use one, ask, how may I address you? If you ask everyone what pronouns they use in a group setting, then no one is singled out. I've been in more and more situations where when you go around the table or go around the Zoom call and introduce yourself, you're asked to share your correct pronouns and correct name at that time, and everybody does that so that nobody feels excluded or singled out or called out in any way. Okay, so I have a couple of examples, and then I am going to open it up to any questions, because I know Kim said we have a couple. So in my first one, Brianna has supervised the same group of people for 10 years. A few months ago, one of her team members, Adam, transitioned from female to male. Brianna calls Adam by the female pronoun repeatedly, and Adam corrects her each time. 3 months after Adam's transition, Brianna is still using the incorrect pronoun and is not correcting other employees who do the same. Is this illegal? Yes, I think you are definitely in the illegal realm here. Brianna appears to be doing this deliberately. It's been a significant amount of time since Adam's transition, and makes it less likely that Brianna is doing this by accident. And the fact that she's not correcting other employees who are doing the same thing, whether they're doing it accidentally or not, is further evidence that she's doing this on purpose. This certainly could be something that contributes to a discrimination claim should Adam choose to bring one. So Sandra, my second example is Sandra. Sandra was hired by XYZ company 2 months ago and has been using the women's restroom ever since. Recently, one of Sandra's coworkers learned from a mutual friend that Sandra is a transgender woman. This coworker refuses to use the bathroom with Sandra anymore and tells HR that she feels unsafe doing so. She demands that the company stop Sandra from using the women's restroom, saying it's giving her anxiety at work to share the restroom with Sandra. This is a little bit of a twist on the religious objection. Now this person is saying she feels unsafe, not necessarily due to religious belief, but it's giving her anxiety and stress, possibly venturing into a disability. She's saying she needs to be accommodated, and her accommodation that she's suggesting is that you don't allow Sandra to use the restroom with her. That is not an accommodation that you can grant. That is putting you in undue hardship territory, because to grant the accommodation that this coworker is asking for, you are violating the law. And whenever you have to grant an accommodation that violates the law, that is per se an undue hardship under the state and federal laws. So, you know, Sandra, you may be able to accommodate the coworker in other ways. You know, maybe open up a single-use bathroom for everyone to use. But what you don't have to do is discriminate against Sandra just because the coworker feels unsafe. Okay. And then this is my last one, and this is on religious discrimination. Adam has been an employee of XYZ company for 10 years and is devoutly religious. He's recently learned that one of his coworkers, Eve, identifies as a non-binary individual. Yesterday, Eve said to Adam, the pronouns that should be used for me are ze, them, their. He refuses to use Eve's correct pronouns, and when the HR director tells him he has to, he threatens to sue the company for religious discrimination. Again, we've looked at this. This is not a religious accommodation that you need to give Adam. You don't have to accommodate Adam at the expense of breaking the law when it comes to Eve. So that is the answer that I would give Adam. And if he wants to sue, he can bring it on because we have a good defense. Okay, I'm happy to take questions. Kim, I can't actually see the Q&A, but if you want to read them to me, that would be great.
Happy to do that. All right. So we have a lot of questions here, or several at least. The first one is, can you explain how GRA might apply to minors?
Yeah, so GRA, you still need a parent's consent if you're under 18. So a minor can't independently file for the name change or pronoun change. You have to have the parent or legal guardian's permission and consent.
All right. Thank you. All right. The next question. Have there been any cases analyzing the use of incorrect pronouns since New York changed the severe or pervasive standard for hostile work environment claims?
That's an excellent question. I look this up every few months. I still have not seen one. I certainly think with the standard being lower and the and the law is getting stronger, using incorrect pronouns is going to amount to more than a petty slight or trivial inconvenience. But no, I'm not specifically aware of any cases on that.
All right, thank you. And this question goes back to the restroom issue. Can employees who are gender fluid go back and forth between using the men and women's restrooms or locker rooms?
Yes, they can.
I'm sorry, I'm trying to get rid of I'm trying to do tech things at the same time. You know how this goes for me. Okay, so the next question, can you discuss the Meriwether case and what it means for requiring correct pronoun use in the workplace? And if you don't, if you're not, we can table that.
We'll move on from the Meriwether case.
Move on. Sorry, we're not able to answer that one right now. All right. So next, can state law claims such as gender be waived in a separation agreement general release? And if so, do any special considerations need to be given to the language of the agreement or release?
You know, I just got asked this question a couple days ago. And you're lucky I did because I know the answer. Generally, when you're waiving state law claims, you can include them in a general separation agreement and release, just the way you include any other state law claims. If you're releasing them pursuant to a claim of discrimination or harassment, there was a part of the New York human rights law that was changed back in 2019, requiring you to give sufficient notice and time to revoke. And you cannot make people sign confidentiality with underlying facts and circumstances of the matter unless you follow those stricter parameters. So almost like what we do with older worker benefit protection acts releases, you would have to do if you had a claim of discrimination or harassment and wanted to include confidentiality provision in that.
All right, thank you. And Katie, Teresa, you got compliments, including from Katie and many others on your presentation today. And the sun even came up because you're doing such a job.
Not here.
All right, so we have a couple of more questions. What are current ACA healthcare coverage policies regarding gender identity healthcare issues?
What a lovely question for a benefits lawyer.
Yes, I think so. So thank you for the question.
I think it's a great question. I'm not qualified to talk about the ACA, but we certainly have people here who are. John Gotzo, Aaron Pierce, people who come to mind. It's a good question and one worth answering, but it's not one that I can answer.
And one where we certainly have folks here at the firm who can answer that question if someone wants to reach out. All right, the next question. Do you know how these laws are applied to healthcare situations, healthcare employers, where patient-facing employees must use their name to satisfy laws that patients know the name of their provider?
So this is actually interesting. The New York State, or maybe it's New York City, one of them has an entire set of guidance specifically for the medical field on the issue of gender identity and sexual orientation in healthcare settings. So I'd encourage you to check that out. I think that would probably be the best place to get your answer. In general, when there's a law requiring you to disclose someone's gender identity or pronouns, if it's a law that you have to use their legal gender identity or pronouns, then that's what you have to do, even if those aren't the correct ones that the person uses in their everyday life. then, you have to explain to the person, listen, we have a legal requirement to put down your legal name and your legal pronouns, although I think pronouns is less likely. We have a requirement to put down your legal name. I know that's not your correct name, but this is the law and we have to follow it. And most people are understanding of that. Short of that, if it's something within your control, if it's an internal procedure, something like a name tag or a business card or email signature, and there's no specific law saying that you have to use the legal name, use the name that the person tells you to use their correct name and pronouns.
And we had that at the law school with a graduate who hadn't gone through the name change process, and the name on the diploma has to match the application to the bar, and it has to be the legal name.
So, perfect example.
Yeah, we had to take care of that. All right, so we did have one comment as well about a medical issue that employers might consider is an employee who lawfully changes the gender to male has changed for all employment purposes, including benefits. Upon changing the gender with health insurance, the employee became entitled to medical care for males under health coverage, did not have OB/GYN coverage. The employee then became pregnant and wasn't covered for OB/GYN. So the employer had to do some work to reverse the coverage, but it's something that sort of should be open for consideration for people by the employee and the health insurance company.
Oh, absolutely. And it's because a lot of these regulations and rules surrounding insurance, they just haven't caught up to where we are yet.
Right.
The law is gradually catching up, but it unfortunately takes more time than it should.
Yes, and sometimes we change one piece and forget the other moving pieces that need to be changed.
Happens all the time.
It does. Absolutely, but that's why we have to keep working for it. Well, Teresa, your timing was spot on and impeccable, but more importantly, your content. It was great. And I really can't thank you enough for providing this information today and keeping us updated on this really critical issues surrounding gender identity so we can create more inclusive workplaces and a more inclusive legal profession. So thank you so much for your time.